Good evening, friends. Those who have been following up with Beyond Law CLC YouTube channel, they know that Professor Nilima Bhadbhade has taken topics on contract law and various perspectives of law, which we all know that in the subtle manner in which he explains things, people actually look forward to understand the nuances of that. In this journey wherein we have tied up with ICFAI University to share the knowledge, being a knowledge partner on various perspectives of law. And this is the fourth part in that series. Madhuri Pandhir, an assistant professor in that university, is here amongst the students also. I will not take much time, and I will request ma'am to share her knowledge. And we are glad that despite her busy schedule, writing books, going to different places, sharing her legal knowledge, that she has accepted and acceded to our request. And over to you, ma'am. Happy New Year in advance.
Thank you very much, Vikasji. Wish you all a very happy new year. And I'm very happy to join Beyond Law CLC in the first month of the year. It is also a great pleasure to meet Madhuri Pandhir and to know that Beyond Law CLC is working along with Big Five. In the list in which I am busy, I would like to add something which I take great pleasure in doing these days. And I have a garden on my terrace, and I spend a lot of time growing vegetables in that garden. My other activity is trying to write about law subjects in simple language, not merely for common people, but also for young lawyers who will find it interesting to read. Today's session belongs to that category. Perhaps we know everything which I am going to state, but I am going to put it all together and state the fundamentals. I will cover only the fundamentals. Beyond Law CLC portal has plenty of sessions. Many of them I have followed and I have heard those videos about probate, about wills, about succession, where practitioners and judges have spoken about the practical aspects of these proceedings. So I go back to the fundamental principles, and after that I will request you to go to the different videos on Beyond Law CLC, excellent videos about probate and wills. Our topic today is administration of the estate of a deceased, the fundamental principles. This is actually a subject that touches upon the lives of all of us. I am sure each of us has or will someday have to take care of the estate of a deceased ancestor. We also think about what to do with our property after us, and we should understand the method of administration after us, and perhaps that will help us take good decisions now about how that property will be administered. Many of us are lawyers or are going to be lawyers, and we will be required to advise our clients. Believe me, that although the law is there, every problem which a client comes relating to such administration, whether there is a dispute or there is no dispute, it is unique. His questions are unique, the situation is unique, the parties involved are unique, and we have to find our way for each situation to cater to what the client wants. And at such times, when the law is there, but the answers have to be given relying upon our judgment, that fundamental principles come to our aid. So let us begin. When we talk of administration of estates, We are talking about the death of a person. So let us suppose X dies and X has relatives. Before going further, let me just check with Mr. Vikas and Ms. Madhavi. Can you hear me well? Because I have a slight sore throat. I
Yes,
will
ma'am, it's
continue.
perfect.
Yes, I will continue. So X dies and he has relatives. These relatives may be very close relatives, like the spouse, children, mother, father, brothers, sisters. Let us suppose X doesn't have these close relatives. He may have remoter relatives, but they are related to him. So there is bound to be some or the other relative in most cases. Now, if he hasn't made a will, then the property goes by intestate succession. That is the first situation. The second situation is where he has made a will, but there is this property which the will doesn't cover. Then that property devolves without a will. Or he has made a will, the will was challenged in the court, and the court has held that the will is invalid. So he dies, or he has died, as if without making a will. And in all these three situations, this is property which will devolve by intestate succession. Testament is a word for a will. Intestate means without being testate, without having made a will. And we all know that when succession is intestate or without a will, different laws apply to all of us. So we ask, what is the personal law of X? What was the religious faith to which X belonged when he died? Look at the sentence. X's religious faith, but at what time? When he died. So if he is a Hindu, he will be governed by the Hindu Succession Act, as also if he is a Buddhist, Sikh or Jain. If he is a Christian, he will be governed, or rather his estate will be governed by the Indian Succession Act. If he is a Parsi, his property will devolve under the Indian Succession Act, but there is a separate chapter. If he is a Muslim, then there are well-known principles. We locate them in some wonderful books about Muslim law, written by Faizi, Mullah's Principles of Mohammedan Law. And based on that, the sharers and the shares can be derived. So, we go to this personal law to find out two things. Number one, who will succeed to the property after his death? So if he is a man and he is a Hindu, his mother will succeed. But if he is a Christian and he has children and husband or wife, his mother will not succeed. So which are the relatives who will succeed? In all cases, the spouse and children will always succeed. The next thing is, what will be the share of such person? And the shares differ. And I will ask you to actually prepare a chart and write down those shares so that we understand those differences. Now, all these persons who are there, let us say a man dies, leaving behind wife, two children and mother, and a father. We all know that the father is not the class 1 heir of a Hindu. So the mother, the wife, and the two children will have equal shares. So each of them will have a 1/4 share. This share is undivided. In Marathi, and I suppose in all languages, it will be called avibhakta hissa. It's not separated. Everybody has 1/4 share in every item in the house, in every pen and paper and stationery which X possessed, in the land and the house which X has. So in everything it is 1/4 share. No one can say that is yours and this is mine. So they all have an undivided share. And this share is known. The task of taking it separately is called partition, and of course we are not dealing with partition. The other thing we remember is that all these four people, or in other cases, whoever are these successors, and we call them heirs, all these heirs, property vests in them immediately after X dies. So the moment X dies, the next moment, if there are four heirs, all four of them have become owners of that property. They do not need any registration, any enrollment. When they go to enroll, let us say for land on the land record, they go there and say that we are the heirs, we have got so much share, therefore put our names on the record. So they have become owners the moment the person dies, and they have an undivided share. Now, what if he has made a will? So X dies, he has relatives, and he has made a will. So his will indicate who is going to get the property. So it might be a universal legatee. I give everything that I may have when I die to my wife. Absolutely. So it may be given like this, or it may be given that I give my house to my son and my land to my daughter and my other flat to my wife, and so on. So they may give separately. So whosoever they have given property, they succeed as is stated in the will. And they succeed immediately. But there are some issues in the issues about this, where we go to the sections under the Indian Succession Act. When do they inherit? When does property vest in them? Let us go to the Indian Succession Act. The person to whom property is given under the will is the legatee, is the beneficiary. And section 104 of the Indian Succession Act, all my sections in this presentation are of the Indian Succession Act. 104 talks about the time of vesting legacy in general terms. If a legacy is given in general terms, without specifying the time when it is to be paid, the legatee has a vested interest in it from the day of the death of the testator. So again, under this section, the property vests in the legatee the moment the person dies. Means he is the owner, he is the legal owner, he is the beneficial owner as well. But if his will appoints an executor, then Section 211 of the Indian Succession Act says that the executor or administrator, as the case may be, of a deceased person is his legal representative for all purposes, and all the property of the deceased person vests in him as such. Here, of course, I am not talking about administrators because they are appointed later by the court if at all you have asked for it. But if an executor is appointed, then all the property in the will vests in the executor. So the executor becomes the owner by name. His position is as a trustee. He is not beneficially entitled to the property. And hence these words I have highlighted. It vests in him as such, means it vests in him as the executor. And this is a Supreme Court judgment which has carefully described it by saying that this vesting is not of beneficial interest, but it is only for the purposes of representation. Remember, the estate is to be administered. We will see later what is administration. but just for that purpose he is the executor. So if property is given to the children and the wife, and the friend is appointed as the executor doesn't own the properties. His only task is to see that the wishes in the will are carried out and the property is administered. But for that purpose, he is considered to be the owner and his position is that of a trustee. Then what the legatees have is the beneficial ownership or beneficial interest in the property. And further, Section 332 provides that in order to complete the legatee's title, the assent of the executor is necessary. So the legatee has a title which is beneficial interest, it belongs to him. But to complete his title, executor's yes is required. And therefore the executor has a role in making the title of the legatee clear. So let us suppose that the deceased has left a flat and his will has an executor. Then the flat falls to the name of the executor, but it is given to his elder son. So the elder son is the legatee. Is the legatee's title complete? No. The executor's yes will be required. So let us look at different scenarios. Let us suppose when the son goes for recording his name in that society, the executor will say, yes, I have no objection. The executor has assented. The executor hands over the money is collected to the legatee and takes a receipt. The executor has consented to the handing over of the money. So, this assent therefore is necessary. And there is a practice that the executor will sign a transfer deed in favor of the legatee, where he says that I release all my right and transfer to you all my interest as an executor. So, Mr. Legatee, here is the document by which I do it. There are, of course, divergent views about whether this is necessary. Such deeds are made, they are registered, and indeed, then the legatee will have a very clear document where he has got it from an executor. And if the executor also has a probate in his hands, then I would say the probate and such a transfer deed is a very good document of title to have for this legatee. But I said, whether this deed is necessary or not, there is a divergence of opinion. One thing is clear, that the assent of the executor is required. So if the legatee wants to sell the property, the buyer should be insisting on the executor's consent. So let us go forward. But these are not the only people interested in the property. More interest in the property after a person has died are his creditors. Why? Because so long as X was alive, he was in a position to repay the amounts of debts. But now that X is no more, then the creditors can collect the amount only from the properties. So they are very much interested in what is happening with the property. So I've used the word interest not in the sense of property law. I've used it in the sense of interest, that they are interested. They are keenly involved in knowing what is happening with the property. And why is that so? Because the estate is liable to pay the debts. So whatever amounts X owes, they may be contractual amounts, they may be loans, they may be price for goods which are purchased. All of them have to be paid. And in fact, there's a provision in the Indian Succession Act which says, in the duties of the executor, that first pay the debtors, then give to the legatees. And for payment to debtors, sometimes properties may have to be sold. So sell the properties and pay the debtors and then hand it over to the legatees. So debts must be paid first. And it is for this reason also, we remember that whenever um, a person dies and he has a liability, and he has a liability towards, let us say, A, then if A gets a decree against the heirs of X, and that amount is, let us say, 1 lakh, and the property is worth only 50,000, then A can collect only 50,000 because the property is only so much. A's heirs are not liable to pay from their own pockets because ultimately, even if X were alive and he were liable and he did not pay the debts, the creditors would have collected it from his estate only, whatever property he had. They cannot go to his relatives and say, you must pay because you are relatives. Therefore, the liability of heirs, etc., is limited to the property in their hands. After that, what? Well, it cannot be recovered. So, our question is, when do successors become owners? When does property vest in them? This is the way we state it legally. So, we have two concepts. One is representative ownership and the other is beneficial. And in the hands of the executor or the administrator, if appointed by the court, their title is a representative title. Who do they represent? They represent the estate. Now, our next question is that let us suppose that the property has come to the legatees, or let us suppose that there are heirs after a person has died. Then the next question is, can they start exercising their powers as owners? Ownership is the right, they have ownership. But what can they do because they are owners are their powers? So, can they use the property? The answer is yes. Can they transfer the properties? Yes. Even the legatee can transfer the property. The executor's consent will be required. Can they collect properties from others from where they are due? The answer is yes. Can they divide the properties amongst themselves? So whatever is in the house, they all see who wants what and they take it away. There is jewelry, so they divide the jewelry amongst themselves. They adjust the price and they take it away. There is a house and it has 2 stories and they have 2 children. So the 2 children and the mother, they have an arrangement where one will have the top floor, the other will have the lower floor. And they actually partition it so that the partition deed gets registered. And they give to their mother the right to stay wherever she likes, on the first floor or the second floor. So can they do that? The answer is yes. So they can practically exercise all the powers as owners once the property vests in them. But then, what is administration? If the person were, or if his Atma were alive, if X dies and his Atma is alive, he will have to go about collecting his properties and distributing them. That is the task the representative, somebody has to do. So the task of collection, management, and distribution of the property of a deceased, based on the law of succession that applies to him, is administration. I have put it in very simple words. There are longer definitions. So what all should this person do? Remember, even if there is intestate, there is intestate succession, and one child has been staying with the deceased, he knows everything about the deceased, where the properties are, everything is written properly in a notebook. he still has to go around and collect that amount, collect the properties. So first is identify what all belongs to the deceased. It is known that the deceased has an account in the bank, but how much account he has, how much amounts he has, you have to identify. So identify so that you can collect those assets. At least you list them down and collect as many as possible. Then this administrator keeps them for a while. Of course, it has to be distributed, but it takes time, till you collect everything. While it is in his custody, he may have to manage it. For example, he has got custody of, let us say, some of the property, and he is required to invest, take away some investment. If it's a house and the tenant has left, he may have to keep another tenant. He may have to get the house painted so that he can find a better tenant. So this is management of the property. Now, from the property, the debts and liabilities are to be paid first. So identifying the debts and liabilities. Please remember, on a personal basis, we rarely keep a list of our debts and liabilities, right? We keep a list of our assets. Now the debts and liabilities are first to be paid off. So how are they to be paid? Which assets are to be first realized for this payment? After that, if there is a will, hand over the legacies. So Indian Succession Act has very beautiful provisions about among the legacies, which ones are to be realized for payment of debts. So satisfy the legacies. Whoever property is given in the will, hand it over to that person. And then distribute the remaining estate depending on the will or depending on intestate succession. And during all this, administration may also involve selling and transferring properties, especially to realize them for the purpose of paying debts and liabilities. So when we talk of administration, we are talking of all these things. And then we ask, who is going to do all that? Somebody has to do it. So who is going to do all that? That person I will call the representative. Now I was talking about the power of the heirs to manage their properties on their own. Somewhere we start believing that without any certificate, we cannot manage the properties. We lawyers are very clear about the law, but that is what many ordinary people believe. My father has died. Now I have to go to court and collect. It's good that he has made nominations, but if there is no nomination, I have to go to the court. Can I distribute this property or do I need a court order? There are many misconceptions. So the fact that the heirs should be left alone to manage their properties is as old as 1799. These are old regulations where these two regulations provide that heirs need not apply to courts for permission to take possession as far as can be done without violence. So the law or the systems or the courts or anyone else from the state need not interfere in how the heirs are managing their properties. Unless, of course, there is an issue of violence. The next thing it said is that courts are restricted from interference except on a complaint. So court should not take any action unless there is a complaint. And then if there is a dispute, they lay down some procedures. The Bombay Regulation Act, which applies today in Maharashtra and Gujarat, and those of you who wish to know more about it, I have done earlier a session on Beyond Law CLC about heirship certificates where I have discussed this in detail. So the Bombay regulation also says, and I go directly to the provision, whenever a person dies leaving property, whether movable or immovable, the heir or executor may assume the management or sue for the recovery of the property in conformity with law or usage applicable to the disposal, etc., without making any previous application to the courts to be formally recognized. So there is no need of coming to the court. Let the heirs manage on their own. There is no problem. Okay. This is what the Bombay regulation also says, not just in section 1, this is the first section in the regulation, but also in its preamble. So the successors, whoever they are, that is the heirs or the legatees, they can use the property in their hands, they can divide and partition, they can sell, they can share income, they can share the proceeds, they can go to various places and record their names, and they can collect amounts from strangers, they can take back possession from tenants, they can collect amounts from whoever owes money to them. They can do it, right? They don't need a representation. So if they want to collect money from a bank, a large amount, they don't need the representation. It is the bank which needs the representation. This is the focus of my discussion today. So I'm looking at this provision from a very different angle. So I have deliberately put strangers in inverted commas because they are now the main people in my presentation. So who are these strangers from whom monies are to be collected, properties to be collected, things are to be collected? So they can be debtors like banks. They could be tenants from whom rent is to be collected. They could be mutual funds and depositories with whom assets are kept in intangible form. They could be persons holding property like gold which is delivered to a jeweler for the purpose of making jewelry. Or they could be record keepers of the deceased property. So I have a vehicle, but it is recorded in the RTO. I have a land and it's recorded in the government record. I have a leased land and it is recorded in the Industrial Development Authority. And so they want to collect the money and the things or have their names recorded. So they go to these people, the strangers. Who are they? They are strangers means they are other than the deceased and the heirs. So I have called them strangers. And they are strangers because they don't know about this deceased person. They don't know whether these are the heirs. So they are strangers. So when they go to these strangers, when they go to the bank, when they go to the mutual fund, when they go to the tenant, the first question is, are they really the heirs of this person? You never know. People have similar names. They might come and say, I am the heir. Maybe the deceased person, his death is not known to the real heir. Someone comes and starts saying, I am the heir. I mean, this is very natural and this happens. Then the next question is, okay, these three seem to be the heirs, but are there any more heirs? I don't want them to come and claim later. Now, if a will is presented to them, is this the valid will? Is it really the will of that person? Is that person's signature? And assuming that it is a good-looking will, even a registered will, is this the last will? Because if there is a later will, that is going to prevail. And these strangers, therefore, have these doubts in mind. And they feel that if we give to these people and the real owners come and ask, I don't have an answer because I'm supposed to hand over to the real person who is entitled. So we start off again by saying that there is no bar to deal with heirs. All these strangers, they are free to deal. So 4 people come. I had taken money from the deceased person. I want to return the money. I know the deceased person personally. I know the heirs also personally. The amount is a very large one, 25 lakh rupees. All 4 of them come and I hand it over to them. I am free. There is no legal bar. So the law doesn't put a bar. But the law enables covering risk. So what is the risk these strangers face? They may have to pay over again if the real owners come. And they may have to spend on litigation. Let us suppose that they have handed over money to 3 people and somebody comes and says, I am the 4th heir. The court may finally decide that he is not the heir. But the bank or the mutual fund is required to spend on litigation where it has been dragged. Or there may be any other liability. And the strangers want to feel safe from this. So the first rule is they can take the risk. Remember when I handed over money to my friend's children? I took the risk because I knew them. So they can take the risk. And that is why when the amounts are small, banks, mutual funds, etc., will hand over the money without asking for court orders. Currently, I am using the word court order without asking for succession certificate. Why? If the amount is small, the bank also can take the risk and they know that no one will file a litigation for such a small amount. So the risk of facing the risk is also very small. So they can take the risk. Some of you may like to go to the guidelines issued by the Reserve Bank of India in September 2025, where the Reserve Bank says that up to a threshold limit, which the bank has put at 15 lakhs, the procedure will be submitting of certain documents, but don't ask for legal representation. So some of you may want to go through those guidelines. So because they want to cover this risk, I come back to my presentation. Because they want to cover the risk, they say go and get yourself formally recognized as the representative. So you have come. I will take it that you are the representative because the court has formally recognized you, and I will pay you because you are formally recognized. So this is how they wish to cover the risk. How is the risk covered? We will see later. Now, this formal recognition of representatives happens in the form of 4 kinds of certificates in Maharashtra, 3 kinds of certificates in other states. One is the probate, which is a certificate granted to the executor of a will. So first of all, the will must have an executor. Second is that the executor should be willing to act. And the third is that the executor should apply for probate. Then it is given to the executor. If the executor doesn't apply, then someone has to apply for letters of administration. Then there is letters of administration. Means what? Somebody gets letters, means a letter which gives authority to administer the property. And this may happen if there is a will, and this can also be obtained if there is no will. Both the procedures are given in the Succession Act. Then there is a succession certificate, which is granted only for debts and securities. And there is the heirship certificate in Maharashtra and Gujarat under the Bombay Regulation 8 of 1827, which is granted in respect of any property. So among these, succession certificate is granted only for debts and securities, and the other 3 are granted for any kind of property. There is also a certificate granted under the Administrators General Act 1963, and you may like to go through that act. Now the proceedings in these are summary unless contested. And if it is contested, then in a probate or letters of administration, in the first 2, the matter is conducted as if it is a trial. Why? Because when the certificate is granted, it has a conclusive nature for this reason. But if there is no contest, then the proceeding is summary. It doesn't amount to res judicata also. When the probate is granted, then it is conclusive as to the title of the executor. that the will is valid and the will is final. Succession certificate and heirship certificate proceedings, even if there is a dispute or even if there is an objection to the grant by somebody, they are still conducted in a summary manner. So what is the procedure? There is an application. In a probate, the executor makes it. In other cases, the law tells who can make it. Then they pray for the certificate and they give a list of properties. This list of properties must be very accurately given. Now, in this proceeding or the application, they have to state the names of the close relatives, because notices or summonses or citations, whatever the names are different, they will be issued to these relatives so that these relatives can come and either say we have no objection, or they can object, or they need not even come. But they are given an opportunity of coming and stating what they wish to state. Then in all these proceedings, there is a provision for giving publicity. So there will be a public notice, right? And there will be fixing the citation, fixing the notice in the court hall and in the collector kacheri and so on. But basically the public notice which gives publicity, which invites people, if anybody has objection, please come and take it. And there is an opportunity to oppose or object to people other than those who are relatives. So anyone who has an interest in the property, remember anybody can't take, he has to show how he is affected. Then he can take objection. He can, for example, take an objection that I have a later will in my name. And based on all that, the court will either grant it or refuse it. If it is granted, then this person is the representative. If it is not granted, well, things are where they were, right? So the property is there, the heirs are there, they own the property, so they can decide how to proceed further. So these certificates, the most important part which will be there is the name of the representative, the list of properties which gives details and the value. Because if you go to the bank will see, is this in your name? And then it will see, is this deposit or whatever mentioned in the certificate? And court fees are payable at the certificate stage. Remember, application has small court fees, but when the certificate is granted, substantial court fees are to be paid. Now, this is an important part. The effect of certificate. The first thing is that the certificate is conclusive as to the representative character of the grantee. So if I have a succession certificate to collect the debts of my ancestor, and I go to the bank or I go to some other debtor, right? Some other debtor I go and I say, give me the money. That person cannot challenge my representative character. He cannot say you are not the representative. He has to accept me as the representative of the deceased. So even if this were a litigation, he can't say Nilima Bhadbhade is not the heir, but XYZ is the heir. So long as I hold the certificate, my entitlement to receive that property cannot be denied. And this applies to all the certificates. But this debtor or whoever is that person is not bound by it because they are not parties to the proceeding. So if I take this letter, succession certificate to the bank and I say, give me the money, the bank will say, we will not give you the money because we have a lien. Right? I go to a debtor and I say, give me the money. The debtor can say, I won't give you the money. I say, what is the reason? He says, no reason. I just won't give you the money. Go. Remember, even if my ancestor had gone, he would not have given the money. So the fact that there is a certificate doesn't bind the strangers. They are not parties to the proceeding. If they decide to act on it, they get a discharge, but they are not bound to do so. Next, There is a misconception, especially among common people, that a person who has the certificate, for example, if I get a succession certificate, then all those amounts are mine. I become the owner of it. They feel that the grant of representation is a recognition that they are the heir. No, they are only recognized to represent the estate of the deceased for the purposes of administration. So, none of these certificates confers title on the grantee, except probate, which confirms the title of the executor, but that also title as such. Remember, it's not a beneficial title, and it does not guarantee the deceased title. So if plot number 55 is mentioned in the probate, that doesn't mean that the deceased owned that plot. It has been stated, information given to the court, and that is what has gone into the certificate. So these courts will prima facie see whether the property belongs to this person or not, so that it can be put in the certificate. But otherwise, they do not guarantee that that is the title of the deceased. So let us suppose that based on that probate, I file a suit, against a person saying that this was owned by the deceased, hand it over. That person can always say this was not owned by the deceased because it was of my ownership for this reason. Now, if the debtor doesn't hand over, or if possession is not handed over to this representative, then this representative is required to file the suit or whatever is the appropriate proceeding. And the certificate is also mandatory under Indian Succession Act for enforcing debts. So, because of paucity of time, I will not explain this much. It says that no court shall pass a decree against a debtor of the deceased or proceed to execute against such a debtor a decree, except on the production of probate, letters of administration, or succession certificate, or heirship certificate under the Bombay Regulation Act. There are also other certificates. We need not be concerned with them. So if I want to recover a debt owed to the deceased, it becomes necessary for me to obtain a succession certificate. Of course, I can file the suit, but before passing the decree, I will need the certificate. If there is already a decree in favor of the deceased and I am the representative, I will need a succession certificate to be able to enforce that decree. Proceeding can be filed because there are limitation issues involved, but the enforcement will not happen until the succession certificate is obtained. So we always remember this section. This is mandatory. Now, what the strangers want. Okay, let me cover this. There's also something called a declaratory suit. I mean, I am one of the children. I go and get a succession certificate. I collect the debts. I can't use the certificate to say, well, I am the heir, right? If at any time I want a declaration of my status that I am the heir, or that I have a 40% share or a 1/3 share in the property, then I have to go in the civil court and file a suit for declaration. A declaration of ownership or a declaration of my share, a declaration that I am one of the heirs, and so on. And this is done by filing a declaratory suit under Section 34 of the Specific Relief Act. All these certificates merely give the power of representation. They do not declare anyone as the heir. The only exception to this is the executor who has a probate. Now we saw that the strangers want to cover the risk. I go back to the strangers. Where is this given? As regards probate and letters of administration, Section 273 says that when these debtors pay or persons deliver property to the executor, the holder of the probate, they get an indemnity. To whom should they deliver? To the person to whom the probate or letters are granted. Similarly, in the succession certificate, where payments are made to the person to whom the certificate is granted, and the payment is made in good faith, and such debts or securities means the earlier part of the section says those which are mentioned in the certificate, then only these people get full indemnity. And this section also applies to heirship certificates. I have discussed in great detail in my other lecture that heirship certificates in Maharashtra tend to be granted without reference to any property. It's just granted and property is not listed. If that is the case, then the person who pays on the basis of such heirship certificate will not get an indemnity, because the requirement of indemnity under 381, which applies to heirship certificates, is that the property must be mentioned. It's only the mentioned property that the indemnity is available. Now I come quickly to section 213, which has been deleted. Section 213 of the Indian Succession Act provided that if you want to exercise any right as executor or legatee in a court, then you cannot do so unless probate is obtained. This is the rule applicable to everybody. And then it said that so far as Hindus, etc. are concerned, this applies only if they have immovable property in Mumbai, Madras, Bombay, Madras, and Calcutta. It's a longer section, I've summarized it. So if I'm a Hindu and I have property in Pune where I stay and I ordinarily reside in Pune, then for my estate, probate will not be required. But if I have an uncle who has died in Bombay and he has property in Bombay and he has made a will, then to enforce any right under the will, probate is required. This was discriminatory. It delayed administration. It delayed dealings in property. It involved costs. And it was really unnecessary. I mean, properties in Pune or properties in Hyderabad are as costly as they are in Bombay, Calcutta, or Madras. So there's really no sense in retaining this discriminatory system. So the 2025 amendment, which is the repealing and the amending act of 2025, in the schedule, it provides, just a minute. Yes, this is the repealing and amending act of 2025. And in the second schedule, in item number 3, it makes these amendments in the Succession Act. It is very surprising that it came as an amendment in the Repealing and Amending Act rather than in a direct amendment to the Succession Act. So in section 3, the figure 213 shall be omitted here. Okay, not very significant, so I won't discuss it. The entire section 213 shall be omitted. I read 213 just now, and the second part was about when it will apply to Hindus, Buddhists, etc., and some more provisions. So this entire 213 has been deleted. And in section 370, some changes are made. So this is 370, which is about succession certificates. And it said that where probate was compulsory under 213, succession certificate should not be granted. So now that part has been deleted. So what is the effect? Are probates compulsory? No. And it is my interpretation that they were not compulsory under 213 also. Enforcing rights under a will was barred. Everything else could be done. This is my interpretation. So, probate can still be obtained in order to get a very clear title to the property for the future. It is a good idea to obtain a probate or letters of administration, but that is not necessary. However, suppose parties wants to have their name, a person wants to have his name entered in the land record. So he produces a will and he says, please put my name. And the other relatives object to it very heavily. Then the revenue officer cannot take a decision. So he tells them, go to court and get a court order. So they will have to go to court and get a probate or letters of administration. Usually the revenue officer doesn't say, get a probate. The revenue officer says, get a court order, right? And the court order can come. So probate is still not compulsory. It can still be obtained. It is advisable in certain cases. And it may be required to be obtained when there are disputes. So I think I will stop there. It was a pleasure to discuss this topic with you. And if there are questions, I will take them.
I'm just taking them. Just hold on. As usual, you summarize the things in such a beautiful manner that it's a pleasure always hearing. Yes, ma'am. Ma'am, though you have covered it, for a common man and to just have a gist, what is the difference between a succession and an estate administration as such? If you have to summarize in few words. Hello.
Session, can you hear me?
Chance your video is not coming forth. Madhuri, you are able to see?
Yes, sir,
My
ma'am.
video is
Actually, through two different windows.
No. But I think ma'am has closed the other window.
Actually,
No, I
both
only
are.
closed the presentation.
Yeah.
My video is there. You can pin that.
No. I'm saying I'm not able to see your face. Madhuri, you are able to see?
Yes, sir. Ma'am is visible on another window.
Okay. Ma'am, what is the difference between succession and estate administration?
Succession is the process by which property devolves upon the heirs or the legatees, depending on whether there is a will, after the death of a person. Actually, successors will include successors of a company as well. So when the company is wound up, which company will succeed to it is also a successor. But in terms of individuals, succession means the process by which devolution of property happens. And estate administration actually means where the property is to be collected, managed, the debts are to be paid, and then the property falls actually into the hands of the people who are entitled to it. It should fall in their hands, right? That process will be administration.
And somehow what has happened is that you have muted yourself where your video is visible and perchance the other part is not available. So what you can do is you can close this window and you can start speak from the other one. I will allow you to unmute yourself. Yeah. And the other one, you can close it off. Yes, ma'am. Is it fine now? Just unmute yourself. Yeah. Now it is, when is the probate mandatory and when it is not?
I'm speaking from this one.
Do I repeat the question, ma'am?
No, just a minute. Can you see me now?
Yeah, perfect.
With the two words? Yes.
Picture perfect.
I want this one now. Yes, please come.
Yes, ma'am.
Please repeat the question.
When is the probate mandatory and when it is not?
With the amendment in 2025, okay, it was considered to be mandatory where a person left immovable property in Mumbai, Madras, or Calcutta in the original jurisdiction, right? Not the entire of Mumbai, but some parts of Mumbai. So I will not go into that detail because I don't know it myself. And if he ordinarily resided there. So he had his abode there. Then no right could be enforced in the court under the will unless there was a probate. This was the provision. It was believed that this provision made probate mandatory. I say it was believed because I never believed. I believe that if you want to go to court, right, then you need the probate. But between parties themselves, they are free to do whatever they like. Anyway, this provision of 213 has now been deleted. So probate is not mandatory. What is meant by probate? The executor files a probate application in the court, and the court grants a certificate that the certificate says that what is attached is the final and valid will of the deceased. So a probate is a certificate that the attached document is a final will and a valid will of the deceased. So it's not mandatory to get it at all. It is advisable in many cases because the property is already owned by the successors.
Though you have explained it, ma'am, since we are taking the question at the end, what duties and liabilities does an executor owe to the legal heirs?
Well, he has to take care of the property. He has to ultimately distribute it. He has to administer it in different ways, which I narrated. But these duties are given in a lot of detail in the Indian Succession Act. There's a whole chapter about it. So I will request the person who has asked the question to go to the Indian Succession Act, where they have all been given in great detail.
This is one of the normal questions is, what will happen between a conflict between a personal law and statutory provisions in the estate matters?
I wish I had an example, because the personal law also gives clearly the shares, and personal law is also statutory, except among Muslims. And what the Indian Succession Act, the part which I discussed, is not personal. It is procedural, mainly procedural, and it applies equally to everyone. Some provisions may not apply to Hindus, but they are of universal application.
And like you had spoken in depth regarding that, let's assume you have inherit debt from the person from whom you have inherited the property, and there are creditors. Then what do you, what was the provision? Because you had spoken in general that payment has to be made by the successors.
The estate is liable.
Because under the Contract Act, there is a specific provision, probably Section 44, I believe, that you have to make payment.
No, so far as loans, etc. are concerned, the liability for the repayment of loan is a payment of agreed sum. Whenever there is a contractual liability and there is death, unless the contract is a personal contract, like an artist painting a portrait, the representatives are liable under that contract. So they may either perform or they will be liable for breach. Whether the promisee enforces that against the heirs or not, or he thinks it is useless, is his point of view. But debts are to be paid before the estate is distributed. So let us suppose that my ancestor had a debt, large amount, and I have inherited a house. And the person to whom the debt is owed files a proceeding against me. Then in my hands, this house can be sold for recovery of that debt, because I have inherited it.
Yeah. Two questions are on the chat box. One is distinction between a probate and letters of administration.
A probate is granted to an executor of a will. Actually, both of them enable the grantee to administer the estate, means to collect the amounts, to distribute the legacies, etc., to manage the properties. Their duties are also similar. But the executor might have more powers if the will has given them. But in some cases, for example, if property, movable property is to be sold, then the administrator needs the court's permission. So, there are slight differences in the powers. The executor is chosen by the testator, and he applies for a probate. So he gets a probate stating this is the final and valid will, and his powers flow from the will. Whereas an administrator is appointed or chosen by the court, his powers begin after he is appointed, but they relate back to the date of death of the deceased. And he will have only those powers which are given in the Indian Succession Act or which the court has given him. They both administer the estate. They both have to give an account to the court. I did not mention it, but all the representatives have to give an account to the court of what they have collected and that they have distributed.
And last question, whether the stamp duty attracts for transfer of property from the executor to the beneficiary.
Yes, I believe it will be small. I believe it will have the stamp duty of a release.
Yeah.
And I will have to ask someone, that is not a practice in Pune. I will have to ask someone who actually does it. So I will ask somebody in Mumbai how much it is, or maybe I will ask the registrars here to find out.
Thank you, ma'am.
But
And
I suppose it will be about 500 rupees, not more. Registration fees might be higher.
Madhuri, we are winding up. You can make a submission.
Yeah, yes, sir. So thank you so much, ma'am. I am Madhuri. I'm an assistant professor at ICFI Law School, Dehradun. We, in our audience, we also have students. On behalf of the students especially, and on behalf of ICFI Law School, I would like to thank you for giving us this opportunity. It was really an honor to have you. And we would like to thank Mr. Vikas Chatrat also for his keen interest in advancing knowledge and bringing the practical insights to the academics. So we are thankful to you both, and it was really an honor and a privilege to be part of this. So thank you so much, ma'am. Thank you so much.
Thank you, ma'am.
Very much. It was my pleasure.
It's always a pleasure hearing you.
Yeah.
Thank you, ma'am.
Bye.